My name is Jennifer Riley. I'm a partner at Seyfarth Shaw in Chicago. Today we're going to talk about workplace arbitration programs. If you've never thought about adopting a workplace arbitration program, or if you've thought about it and elected not to adopt a workplace arbitration program, now is a good time to reevaluate. Let's talk about arbitration in general. Arbitration is an alternative dispute resolution process. A third-party neutral or panel of neutrals issues a binding decision that resolves a dispute between the parties, separate and apart from the court procedures or litigation process. Employers who've adopted workplace arbitration programs have generally done so because they tend to be more informal and streamlined. They also tend to be quicker and more cost-effective, and usually they're confidential. A workplace arbitration program generally requires all employees, as a condition of their employment, to file any claims through the company's dispute resolution process rather than in court. On the other hand, employers who've elected not to adopt workplace arbitration programs have generally reached that decision because arbitration tends to be less predictable than court proceedings. Arbitrators are not necessarily bound by any particular rules of procedure or rules of evidence, and parties have limited appellate options. That means that errors can more often go uncorrected. The downside risks of arbitration are amplified in a class action. A class action in general is a representative action brought by, for instance, a former employee on behalf of a group of unnamed individuals. For instance, a former employee might bring suit on behalf of all current and former female employees of your company, or on behalf of all hourly workers. The risk of arbitration is aggregated in such a scenario because an arbitrator would be deciding not only a dispute between two parties, but a dispute among the entire class and the employer. For instance, hundreds or thousands of employees and the employer. Which brings me to two important points. Employers now may be able to adopt arbitration programs without exposing themselves to class action arbitration. And, importantly, employers may be able to use arbitration agreements as a method to avoid workplace class and collective actions altogether. The Supreme Court has issued a series of opinions over the past few years that are very pro-arbitration and at the same time very anti-class action. The court got the ball rolling in Stolt-Nielsen versus Animal Feeds in 2010. It decided that courts must enforce arbitration agreements according to their terms. That is, parties can't be compelled to submit to class arbitration unless they've agreed in their contract to submit to class arbitration. The court continued this trend in AT&T Mobility versus Concepcion, decided in 2011. In that case, the Supreme Court decided that state laws requiring the availability of arbitration interfere with the fundamental attributes of arbitration and are inconsistent with the Federal Arbitration Act. Then, in American Express versus Italian Colors, issued in 2013, the Supreme Court directly addressed class action waivers. In that case, the court held that class action waivers in arbitration agreements are enforceable even if the expense of individual arbitration outweighs any possible recovery. What these cases have in common, though, is that none of them arose in the employment context. The NLRB has said that the employment context is different. In early 2012, it held that D.R. Horton violated the NLRA, or National Labor Relations Act, by requiring its employees to sign arbitration agreements that prohibited them from pursuing their claims in a class or collective action. Furthering the judicial trend I was just talking about, favoring enforcement of class and collective action waivers, the Fifth Circuit Court of Appeals recently reversed the D.R. Horton decision. But, of course, the NLRB has petitioned the Fifth Circuit for a rehearing. To the extent employers were waiting for the D.R. Horton decision to be overturned before implementing arbitration programs, their green light for implementation is probably not too far away. Which brings me to three key questions. Number one, should you adopt an arbitration program? Number 2, what tools do you need to make the arbitration program accomplish your objectives? And 3, how should you draft your arbitration program to anticipate challenges? We'll address each of these in turn. First, what factors should you think about when considering adoption of an arbitration program? Here are a couple of the items that you should think about. First, has your company been sued in a class or collective action, and do you consider your organization at risk for additional lawsuits? In the wake of the Supreme Court cases I mentioned, like Concepcion and Amex versus Italian Colors, the benefits of avoiding a class action lawsuit may outweigh the risks associated with arbitration. Second, what is your organization's philosophy with regard to defending employment-related lawsuits? For instance, do you try to resolve all of your employment-related lawsuits on summary judgment, by settlement, or are you committed to taking them to verdict? The advantages of arbitration are amplified when employers commit to taking their cases to judgment rather than seeking early settlements. 3, in what jurisdictions are you generally sued by your employees? Many jurisdictions offer significant opportunity for favorable and cost-effective results on summary judgment, while others remain unfriendly to employers and less likely to resolve matters on a dispositive motion basis. Further, does arbitration make sense for all employees at all levels of your organization? Arbitration provisions may make sense for particular groups, but not for others. How does arbitration fit within your overall employee relations strategy? An arbitration program may result in pushback from some employees, so you should consider whether such a policy is in line with your organization's employee relations goals. Before you adopt an employee arbitration program, however, thinking that it's simply going to be quicker and cheaper than litigation, let's review some of the cons. First, employers who adopt workplace arbitration programs generally do see an overall increase in the number of claims asserted by their workforce. Second, an employer may have to pay for the entire proceeding, including arbitrator fees and service provider fees. Third, an arbitrator may have a financial incentive to deny dispositive motions or not allow that type of an early resolution procedure and hold a lengthy hearing. Fourth, an employer may see more compromise awards coming from an arbitrator. Fifth, employees may file lawsuits directly in court, necessitating costly pre-arbitration motion practice to move the proceeding from court into arbitration. If you've decided to implement a workplace arbitration program, there are certain best practices. First, you should invest in developing a program that accomplishes your objectives. Second, you should make sure that your arbitration agreement is in writing and in a separate document. You should state in the arbitration agreement that it covers all of the employee's rights of any kind arising out of employment, hiring, and firing. You should explicitly state that the arbitration agreement covers all discrimination and harassment claims, including sexual harassment. You should explicitly state that it covers all related entities and managers. Further, you should explicitly state that the employee is agreeing to waive his or her right to a jury trial. You should state that the agreement does not create any new substantive rights. Also, you should include a copy of all applicable arbitration rules. In addition, you should provide for a selection of a neutral arbitrator. You should provide for meaningful, albeit limited, discovery. You should allow recovery of all types of relief that would otherwise be available in court. You should provide that the employer will pay substantially all of the forum costs, including the fees of the arbitrator, to the extent required by law. And finally, you should require a written award to allow for adequate, albeit limited, judicial review. You should include a carve-out that permits the filing of administrative charges with administrative agencies like the EEOC. You should avoid using language that preserves the employer's right to amend or modify or cancel the arbitration agreement, and instead use language that disallows retroactive changes and provides a 30 or 90-day notice period before future changes become effective. You should try to preserve all applicable statutes of limitation, and you should avoid any confidentiality language that could be interpreted, in particular by the NLRB, as restricting an employee's ability to build his or her case by talking with coworkers or by seeking witness participation. Your arbitration agreement should also expressly address class and collective action arbitration. If you want to require employees to arbitrate disputes, but not on a class or collective basis, make sure that your agreement explicitly states that class or collective arbitration is not permissible. You should include specific severability language, making clear that in the event of a waiver of class, collective, or representative action is found to be unlawful or unenforceable, then the only forum for such an action would be court, not arbitration. You should also include language that requires a court, not an arbitrator, to resolve any disputes about the enforceability of your class action waiver language. Beware, however, you could end up with multiple single plaintiff arbitrations. If you have any questions or would like to discuss any of the material I've covered, or for a copy of my presentation, please feel free to contact me by email or phone. Thanks very much.